Hi, so welcome to the live lectures today, and we are going to be looking at the business and corporate law fundamentals, where we take you to the courtroom, sharing with you some business lessons on cases that have been adjudicated in the courts and the various things that we can take from it to help us as we are building businesses, but most importantly, also help us, those of us who are writing the ICA, ACC, or the ICAG examination in respect of how these things are going to be feeding into the syllabus and the various questions that the examiner is going to be asking us. And today we're going to be looking at two interesting cases, one in relation to corporate governance and selection of directors, and the other relates to selection of business partners and how, if the right partner is not selected, it results into significant aftermaths that may not be to the will of the various parties involved. And I believe that is going to be a great session to really bring some light into the discussion and help us to really have some understanding generally at the end of the day. So let me bring up my screen quickly and then we can get excited into the discussion. Now, the first case we are looking at is the case relating to the qualification of directors, because the Companies Act 2019, Act 992, was enacted and assented into law, and it gave details on who can be a director. And so when that act was enacted and it came out, some people didn't agree with a particular segment about who can be a director and who cannot be a director. And so the case was taken to court, and we want to walk through that and see how that turns out and pick some lessons from it. Now, generally, from KG2, we learned that everyone can be a director as far as the person is of a sound mind of the company. But then, after the banking sector cleanup and the poor corporate governance that resulted from that, the government then decided, and the various institutions decided, that it is important we have a robust governance system in place to ensure that not just anybody can be appointed to be a director of a company or to be a manager of a company due to the various issues that happen in that banking sector cleanup and the various financial institutions involved in the mix. And so the case we are looking at in the discussion here relates to Edu Jemfi versus the Attorney General. So Edu Jemfi versus the Attorney General, and the date of judgment was on the 8th of November 2023, and it's from the Supreme Court of Ghana, and that is the original jurisdiction, the Supreme Court of Ghana, to give an interpretation, because what was in the act was contrary to what was fundamental in the 1992 Constitution. And so Edu Jemfi went to courts to seek the Supreme Court interpretation and, most importantly, ensure that the right thing is put in place generally. So let's come in and look at what is the key contending issue here. The barring of a person just because she has been charged with those criminal offenses means that she is being punished and denied her rights to participate in a company as a director on account of being charged with the criminal offense, even though the Constitution says that she is innocent of the criminal offense until proven guilty. Now, the critical threshold is that the law penalized individuals prior to any judicial finding of guilt. And so that was the argument of the basis why they said, hey, as far as your issue is in court, you have been charged for something, a crime or something like that, you cannot be a director of a company again because you are already in court and be charged for something fraudulent. But the Constitution says that a person is not deemed to have committed any crime or committed any offense until the person is found guilty by a court of competent jurisdiction. And so saying that somebody cannot be a director of a company just because the person is being sued or has been charged, it means that you are denying that person's constitutional right to fair trial and to be innocent until proven guilty. And so what was the argument? Simple. This was the Attorney General's agenda. The Attorney General was like, hey, listen, The 2017-2018 financial crisis set the tone for that particular clause in the Companies Act 992. Because the Companies Act 2019 at 992 introduced stringent measures to safeguard investors, shareholders, and the public from corporate mismanagement and fraud. So this was the argument of the Attorney General that, hey, listen, we cannot allow people who have been charged for engaging in something fraudulent, a criminal thing, be a director or be directors of a company. So that was the state's argument. Why? Because we need to safeguard investors, shareholders, and the public from corporate mismanagement and fraud. Okay. Then the applicant said, hey, listen, we got to look at the Constitution. So the constitutional guarantee. And so Articles 15, Clause 3, Article 19, Clause 1, Article 19, Clause 2C says that the 1992 Constitution of Ghana guarantees human dignity and mandates that every accused person is presumed innocent until proven guilty by a competent court. So this was the primary argument of Edu Jenfi that, hey, listen, this is the Constitution. No matter what you claim the person has done, the person is presumed innocent until a competent court finds the person guilty. Okay. And so let's look at how the plaintiff targets went. So the first thing is the statutory declaration. The sections 13 clause 2 HI and 13 clause 2 HII forces proposed director to certify they have not been charged with management offenses or crime involving fraud, dishonesty within the last 5 years. So statutory declaration, you have to declare. Once you are being called to be a director of a company, it is a declaration that you have to make that you have not been charged. Now, it wasn't just about charged, because it was just focusing on charged. Because if I'm charged and I'm supposed to declare that, then I'm going to be denied my ability to be a director. Second, automatic disqualification. Section 172 clause 2A I and 172 clause 2A II triggers an automatic ban from directorship upon criminal charge being filed. And so somebody cannot be a director of a company because a criminal charge has been filed. Even if the charge is frivolous, it's meaningless, it's just something somebody wants to get at us or at someone, then you have banned the person from being a director. And this is a serious issue in the context of the fact that, let's say that you are appointed as a director of a company, and somebody doesn't want you to be the director of the company, because they don't like you, because they just don't want you to be associated with the company. You've not done anything wrong. Per the act, what that meant was that if the person just files a lawsuit at the High Court and says, hey, you have been involved in something fraudulent, something illegal, by virtue of the person filing that lawsuit, it means you are disqualified. You cannot be a director of the company. Now, that's such a ridiculous circumstance to be in or situation to be in. And so the judicial discretion, Section 177 clause 1C and 177 clause 1E grants the courts the authority to restrain individuals under investigations or charge. Yes, that is there. So if a person cannot do something, it is not a Companies Act that will say that, oh, by virtue of the fact that you are just being charged, you are not supposed to do something. No. The court can decide you can go here, you cannot go here. You can be a director of this company, you cannot be a director of this company. So that is what we must understand about the target of the plaintiff. So let's come to the pre-verdict choke. So before you get into the discussion of somebody being considered or found guilty, number one, criminal charge will be filed. So a director or applicant is accused of fraud or a management offense. That's step one. Step two, impossible statutory declaration. Section 13 demands they swear they have not been charged. Because they have been charged, they cannot legally sign the document. So that's the second step. Impossible statutory declaration. Because if you have been charged, then you cannot say you've not been charged. Then the third thing, the automatic exclusion, as we mentioned. Section 172 kicks in. The individual is barred from participating as a director. So again, the question is this: is it fair for somebody to be prevented from assuming the role of a director of a company just because the person is being sued for fraudulence or something, when the Constitution says, irrespective of your crime, you are innocent until proven guilty by a court of competent jurisdiction? Is it fair? No, it's not. So let's hear what the court then says. The result of the argument is that the individual suffers a definitive corporate penalty without ever seeing a judge or facing a trial. Guilt is presumed. So, by virtue of the fact that someone has sued you, that you are involved in something fraudulent, that's all. You are guilty. Just because of that, you cannot hold any office or be a director of a company. But that is wrong. So let's look at the interpretation that the two parties boiled down on. So the plaintiff's submission was that an unconstitutional penalty applied before conviction. By virtue of the fact that you are preventing people from being part of directors just because they have been charged for criminal offense or something like that, you have already convicted the person. You have already punished the person even before a court convicts the person. The Attorney General said, hey, the reason we put this clause in the Companies Act 992 is because it's a necessary corporate governance safeguard. That's how they interpreted it. It's a necessary corporate governance safeguard. Okay. The trigger for action. The plaintiff then said, hey, listen, a mere allegation, charge, or pending investigation doesn't qualify me, doesn't disqualify somebody from being a director of a company. Again, the Attorney General's argument was the need to protect the public from repeating the financial sector crisis. Because what happened in the financial sector and that banking sector cleanup exercise was a mess. It was a mess because we had poor corporate governance in place. Some of the financial institutions were taking money and lending the money to themselves like kuli kuli. They were taking depositors' funds and lending it among themselves at zero interest rate for nothing. And people were using depositors' funds to undertake other transactions. They were preparing fraudulent reports and sending same to the Bank of Ghana. So poor corporate governance was really what was there, and that caused a lot of the mayhem in the financial sector cleanup. And so the Attorney General was like, we don't want to repeat that. And so if you have been sued, there is a lawsuit, someone has filed a lawsuit in respect of something fraudulent, you have committed a criminal offense or something like that, we don't want you near any company again because we want to protect the public interest. That was, again, the argument of the Attorney General. Then the constitutional review came in. The plaintiff was like, hey, listen, this violates Article 19, Clause 2C, the presumption of innocence, because you are presumed innocent until found guilty by a court of competent jurisdiction. Again, Attorney General said, it requires a repulsive interpretation. It is a defensive shield, not a criminal penalty. So Attorney General is saying that it's not like we are preventing or we are presuming that the person is guilty. We are only defending, shielding invested shareholders and the public at large from the financial sector crisis repeating itself either in the same financial sector or in other sectors of the economy. So it is not a criminal penalty. So these were the arguments of both the plaintiff and the Attorney General when it came to the interpretation of the law, the trigger for action, and then the constitutional view. And so the question we then have to ask ourselves is, what did the Supreme Court say? So the Supreme Court split verdict. First, the Supreme Court says that, yes, the section that was included in Act 992 of the Companies Act 2019 at 992, stating that someone who is charged for a criminal offense cannot be a director, is unconstitutional. So the court's rationale was that it forces an impossible declaration and inevitably punishes individuals on unproven charges. So the court says, hey, listen, that particular phrase cannot be in the act. Why? Because you are presuming, you are punishing somebody for charges that has not been proven that they have committed. And that is the issue there in respect of that. Then the Constitution, valid because it relies on the court's discretion and authority to restrain rather than automatic legislative ban. So what is the take then? The take then was simple. The act has to be taken out and restructured, that a person shall not be appointed as a director of a company if that person has been charged. So the phrase charged with is now out, so that it will read on convicted. So charged with, or that is no longer going to be in the act. So now that section is going to read, a person shall not be appointed as a director of a company if the person has been convicted of an offense involving fraud and dishonesty, which makes sense. And this was how the Supreme Court brought a finality to the case when it comes to that particular issue in respect of the presumption of innocence of an individual who allegedly have committed a crime until proven guilty. So what does that mean? The Supreme Court surgically redacted Act 992, removing the automatic penalty for pending charges while leaving the safeguard against convicted individuals fully intact. Because if you have been convicted, that one, we don't have any problem. If the court has convicted someone to engage in something fraudulent, a dishonest behavior or something like that, then it's done. So it makes sense to say, let such persons not be a director of a company. However, the mere fact that someone has been charged to have committed a fraud or acted in a dishonest manner does not bar the person from being a director of a company. And that is what we must understand in respect of that. That any statutory provision imposing automatic restraint, penalty, or loss of rights on an individual based solely on a criminal charge without a conviction by a court of competent jurisdiction violates the presumption of innocence under the Act 992, under the 1992 Constitution of Ghana. Because there are two things here. You cannot be, and if you have been following a couple of cases, especially under this administration, cases that IOCO, Special Prosecutor, is pursuing, you realize that in most cases, the people who have been alleged to be involved in some of the issues, their passports and their movements are restricted. And that is because the court has jurisdiction to make that determination. So if they want to travel outside, their lawyers must write to the judge and say, hey, this person is going to travel or this person is going to go here. then the Attorney General is going to come in to either agree or disagree and give their reason. If they agree, then the person's passport will be given to them and they will go and they must return back, or they must come back within the time given. So if somebody is even under investigation, yes, the court has the right to restrict them on whether they can be a director of a company or not if prosecution so wishes that and the judge finds reason with it. However, blatantly or unilaterally putting that as a requirement in an act to say that once somebody is charged, the person cannot be a director of a company violates fundamental human rights, which is everyone is presumed to be innocent until proven guilty by a court of competent jurisdiction. And that is what we must understand in respect of that. And so the last thing then is that the Constitution does not forbid removing a potential dangerous director. It forbids doing so automatically. Judicial discretion remains the vital bridge between corporate integrity and human right. These are the things that we must understand in respect of the case between Edu Gyamfi and the Attorney General of Ghana in respect of that specific clause in the Act 992, the Companies Act 2019 at 992, in respect of who can be a director. So from here on, everyone can be a director except if you are convicted. If there is a court case against you, no problem. It's a court case. You will still be appointed as a director of a company generally at the end of the day. But here is the play in practice. In practice, right? Although this is the position of the law, in practice, there is that perception that is going to surround it. Imagine a listed company is appointing a new non-executive director or a board chairman or a CEO. And this director, a board chairman or a CEO that they are appointing is actually facing trial in court. Imagine. Now, the law has said, now the Supreme Court has said that, yeah, if there is a court case against you, no problem because you are innocent until you are proven guilty. But how there is going to be some reputational damage to the company. Because although this is the position of the law, shareholders think differently. And so the investors, shareholders, and other stakeholders will sit down and will ask themselves, so among all the people, this is the person you found? Somebody who is standing trial for being involved in some fraud or dishonest or some mismanagement. That is the person you are appointing as a director of your company? Okay, then I wash my hand. Au revoir, bon ami. So that is the issue here. Practically, there will be that reputational damage that will come across that the entity may experience. But the law is the law. The law says the person can be a director. But the question is, will the company have the courage to appoint somebody, especially if we are dealing with a public company? They may not be having that ability to be able to establish such companies at the end of the day. And that is what we must understand. They may not be having the ability to appoint such directors, especially if it's in a public company, because of their reputational damage. But this is the position of the law when it comes to who can be a director of a company. So what does that mean? It means that on the overall, it's a good position to be at. Yes, people can establish their own companies. In the private environment, people can be directors of companies and no problem. And that is what we must be mindful of. So that is our first case for this episode. Edu Gyamfi and the Attorney General of the Republic of Ghana, presumed innocent, automatically disqualified people for being directors. The second case we want to look at is an interesting one. It's an interesting one because this case involved a former presidential candidate of the 2024 election and the leader of the new force. And that is in the person of Nana Kwame Bediako, who is popularly known as Cheddar, who is popularly known as Freedom Jacob Caesar. Is it the king of Africa or whatever, the son of Africa, something like that. So the next case we want to look at involves Cheddar. Now, this is an interesting case because you may have heard this in the news where the the famous number one hotel and suites have been taken over by his supposed partner because there is a loan repayment that the partner has made and now taking over the hotel. And Freedom Caesar, Nana Kwame Bediako, has come, issued press conference. The issue has gone to court. And as at today, they have actually received the property because the court has ruled that the property should be given back to him because they didn't follow proper procedures in receiving the property. So at this moment, the property is still under the management of Kwame Asare Bediako. But I want to look at the nuances here. Now, in this case, we don't really have what transpired because the person received judgment in the UK and then came to the courts of Ghana to let the court enforce that judgment in Ghana. And after the court enforced the judgment, Nana Kwame Bediako challenged the enforcement and it wasn't successful, and they took over the building, and later on, they became successful. So we don't have the main issues in respect of what transpired in the UK court. We have not been able to receive information on that. So what we're going to go through and discuss relates to a press release made by Nana Kwame Bediako and pick our thoughts on various things that we must understand and the lessons that we can take away in selecting business partners and how business deals can turn southward or can turn south, if I can put it that way, when it doesn't go their way. So this is it. So it's a press release by the management of Kensington Residential Partners 1 Limited, KRPI Limited. And it's about the Oxford number 1 hotel. They say that, hey, it remains under the exclusive control of KRP1 Limited. Okay, so what were the rumors? The rumors were that the hotel has been seized by a receiver. Yes, as a matter of fact, a receiver was allegedly appointed. I think the same receiver that was appointed for Unibank during the banking sector cleanup, that same receiver was the one allegedly appointed to take over this property. The actual fact is that the hotel is still under the full control and possession of KRP1 management and their directors. But let's break down the conflict. What happened? Why will somebody take judgment from the UK and bring it to the courts of Ghana to enforce in the courts of Ghana? What happened? So let's look at what happened. The conflict stems from an internal dispute between equal shareholders. Stay with me carefully. So at the top, we have the Kensington Residential Partners 1 Limited, who are the developers and managers of the number 1 hotel, Oxford Street Hotel. And the shareholders of KRP1 Limited are Nana Kwame Bediako and Azad Kola. So they are equal shareholders. So the KRPI Limited is a limited liability company owned in exact equal shares by only 2 directors, Nana Kwame and Kola Holdings, or Azad Kola. Now, Azad Kola owns a company called Kola Holding Limited. It's going to come into circle in a moment. So this is what happens. There's a standard loan restructuring that was bypassed by unilateral director action. So what happens here is this. They took a loan to finish the Oxford Hotel and Suites. And they took the loan from IFC in the UK. And so the normal way, if you are having problem to pay back the loan, would have been that KRPI management formally engage the bank to restructure the facility, because the time was due for the loan to be repaid, but we couldn't make the payment because of some nuances, and the nuances were listed here. So December 2019 to 2020, operational and impact. Hotel opened in December 2019 using shareholder capital supplemented by an international finance corporation facility. COVID-19 severely impact trading capacity. So they had some money, they had done the project to a certain point, but they needed some extra money to finish it. And so IFC gave them the facility. But when they opened, 2019, 2020, the COVID and those things, so they were not generating enough money as much as possible. Now, here is the thing that happened. Azad Kola, via his company, Kola Holdings, suddenly writes to KRP1, the company that he is also a shareholder and director of, claiming to have personally repaid the IFC loan in full and demanding immediate reimbursement. Now, this is where I want you to be mindful of what's going on here. Two people own a company. The company has gone to borrow money. Then one person unilaterally got up and said they have repaid the loan, so they should be reimbursed immediately. Who does that? How is that happening? How is that the case? So quickly, you would then understand that there are some things going on between the two parties, which is triggering emotions and taking over of properties. Because following this case and the rumor starting to become public, Nana Kwame Bediako released a video in which he alleges a lot of things which I can't say here because of certainly privacy purposes and legal action purposes. But he alleges a lot of things. Now, from that video, you realize that somebody is not comfortable any longer doing business together. So that was what happens. Azad Kola, via Kola Holdings, said, hey, I have repaid the loan to FIC. Give me back the money right now. So Azad Kola bypassed fundamental fiduciary obligation to pursue a personal profit-making transactions. What should have been the case? Simple. Can directors transact business on behalf of the company? Yes, they could. But what is the standard? Here is the play. Fiduciary duty. Directors must inform the company and seek formal board approval before executing transactions. You cannot voluntarily get up and say, the loan that the company has gone for, you have gone to repay the loan. So let's remit or reimburse you right now, immediately, as soon as possible. No. The standard is that, yes, you have when you are going to carry out any responsibility, you must inform the company. You must seek the board approval. Then you can go ahead. But what did Azad Kola do? He acted unilaterally through an external company, Kola Holdings Limited. I mean, again, it's sort of an interesting issue here because he just used his company to repay a loan that another company that he is a shareholder of takes. And this is where I also have a little misunderstanding, which I will definitely be open for guidelines on. Because IFC lent the money to KRP1 Limited. How is it that you lend money to KRP1 Limited, but that money is being repaid by another company? Like, how did you reach that conclusion? Now, I don't blame the financial institution that much because they want their money and they have collected the money. But it's a bit weird when you lend money to company A, then company B comes and say, I am repaying the loan that you gave to company A. It's a bit weird if you follow the thought process very well, generally. And so, in that case, there is a burden of proof. Financial demands require strict documentation of evidence of payment. Okay, you said you repaid the loan, right? Where are the documents for payment? You give it to us. You didn't obtain board approval. You didn't ask me anything. You've gone to pay. This is Cheddar's argument. You've gone to pay. Okay, where are the documents indicating that you have repaid the loan? What was Azad Kole's action? To date, absolutely zero evidence has been produced to prove the IFC loan was actually repaid. So, Nana Kwame Bediako is saying that Kola has not given me any document indicating that he has actually repaid the loan. So why is he saying he's going to take over my property, the property that we co-owned, and I should give him the money back immediately? Why? Because he has not given me any document indicating that he has actually repaid the loan. Okay, the corporate goal. Secure the best financial terms for KRPI. But then Kola attempted to force KRPI into an unapproved profit-making reimbursement scheme. Because the loan was taken by KRP1 Limited. So if you are entering into any arrangement, it should be in the best interest of the entity. But now you said you've gone to repay the loan. We wanted to restructure the loan. We were speaking to the bank to restructure the loan for us. Then all of a sudden, you have gone ahead to go and repay the loan. Ebajini. So that was the issue in respect of what was seen as the actions. Again, everything that is happening here, we've not heard Azad Kola's side of the story. Whatever we are talking about in this story is what Nana Kwame Bediako is saying. That has happened. But again, it goes back. Why will somebody that you are equal shareholders with in a company, you've established one of the best hotels and suites in Accra, in Ghana. I mean, the Oxford #1 is celebrated. It's recognized, right? And all of a sudden, that co-owner, co-director, equal partner gets up one day and say, hey, I have repaid the loan. Give me back my money. If you're not able to give me back my money, goes to the court, seeks judgment in the UK, came to Ghana, goes to court to enforce the judgment and get a receiver to overtake the property. What would make people do that? I can't tell. But it then means that if you are an entrepreneur, you are rising. One thing you must understand is that nobody is self-made. Sometimes you hear that term, oh, self-made millionaire, self-made billionaire. There is no self-made anywhere. Anybody that you see at the top, anybody that you see who is making money, who has become successful, a millionaire, a billionaire, did it with someone, did it with people. They had a team, they had partners. So if you want to build something big, you want to build something significant, you want to go far, don't go alone. You need some people. You need a co-founder. You need somebody to come in to assist you in financing. In some cases, you need some talents. But you can't pay the talent. So you have to bring in the talent and give them some equity shares in the company. Because that is how big companies are built. That is how wealth is created. But here is the play. When selecting co-founders, partners in a business deal, you have to be careful who you choose. Because that's what's happening here. Because if you don't choose the right partner, you don't choose the right co-founder, when the business starts booming, they will have different agendas. And some of these issues have happened in the case of Facebook, in the case of Microsoft. A lot of issues come up. Even Tesla that you see today, Elon Musk, people will come and say, oh, Elon Musk didn't build a company, he bought the company. Oh, Microsoft, Bill Gates didn't build Microsoft. He stole the idea from somebody, and all of those things. Why? Because in business, when we are starting, everybody seems to be on the same page. But immediately there is significant amount of money coming on the table. If we have not defined terms very well, and you don't select people who have integrity, people who are honest, people who can be trusted, that business that you are building, boom, will become a waste at the end of the day. And so that's a key lesson we got to pick here. Again, all these things are from the perspective of Nana Kwame Bediako. We've not heard Cole's side of the story yet, but my interest is in why two business partners who have built one of the best hotels in Ghana all of a sudden will become enemies, and the kind of words that Nana Kwame Bediako is using and the frustration in his speeches about this whole deal tells that, or says that, there is a lot that weren't really talked about or documented or taken into consideration at the inception of their partnership, which later on years is now affecting the business and their relationship generally at the end of the day. So as an entrepreneur, as a young business owner, coming, you have to make sure that you do not just select any business partner. Select somebody who will protect your interest generally. So let's bring our discussion home in respect of that. The discussion at the end of the day here is that, yes, the business continues without interruption at Oxford #1 Hotel. Why? Because, the argument has been that they didn't follow proper due diligence in seeking the closure of the business and certainly the receiver being appointed to take over the property. So as at now, at this very moment, at the time of this recording, the business is still opened and is under the control of KRP1 Limited. Remember, KRP1 Limited is co-owned and co-directed by Nana Kwame Bediako and Azad Kola. So the question we need to ask ourselves is, what is the way forward? We're going to be following the case, and any updates that comes in respect of that, we are going to provide you with the updates as we proceed in the discussion later, maybe in the next episode or so. Whatever happens later on this pending case, we will feed you and what you must understand. So that's what you must understand in respect of this particular case here, boiling down on selecting business partners. Selecting business partners. And so, again, let's bring the discussion home. If you are somebody watching this and you are building a company, or you want to become an entrepreneur one day, or you want to build something significant, you can't do it alone. Okay? You will need somebody, because it's a good thing. Okay? Being the only owner of a 100,000 cedis company is not good than being, maybe you own only 5% of $1 billion company. That's better, because 5% of $1 billion is more than 100,000 Ghana cedis. So if you want to build something big, you will need people, you will need co-founders, you will need skills, you will need talent, you will need people to come on board with you. But you have to be careful. Be guided well on the kinds of people that you select. And most importantly, make sure that you get a team of lawyers, you get a team of experts to codify how things must be done. Because in my opinion, the reputational damage that the #1 Oxford has suffered could take a number of maybe months or even years to, restore. Because the news has spread. And now if somebody is traveling to Ghana and they want a hotel in Accra, they've heard number one Oxford, and they want to visit there, they'll be thinking, hey, this issue is in court. So, what if I'm there? Remember, it's a residence as well. So, some people were there, and then all of a sudden, they came and they said, you have to leave the place, and that's all. Imagine you are in your hotel. Then in your room, they came in and knocked and said, hey, this building is no longer belonging to this person, so leave here. Will you book that hotel again? No. So the reputational damage is significant, in my opinion. It's going to take time to build that trust back, and most importantly, be able to restore or deal with the issues that they are having as partners in their individual businesses at the end of the day. And these are the things that you must understand when it comes to dealing with the issue about these two cases that I want to draw your attention on. And that's it about that we have to understand. Now, before I go, let me share this quickly. I think the ICAG has released a notice to students sitting for the November 2026 examination. So I want to quickly go through that with you. It says that the registration for the November 2026 examination will open on Tuesday, 1st September to Friday, 16th October 2026. So registration is going to open from 1st September 2026 and will close on 16th September 2026. The examination, which we know already first week in November, will be from Monday, 2nd November to Friday, 6th November 2026. And that's what we need to understand about the examination. So your portal will open for you to start registration from the 1st of September 2026, and you can register for the examination. Few things, biometric verification, something that you need to be mindful of. Candidates are advised that biometric verifications will be conducted before signing the examination attendance register. Candidates will therefore provide their Ghana card numbers during examination registration to facilitate the verification process, and should also bring their Ghana card to the examination center. Candidates should report for biometric verification 1 hour before the start of their scheduled examination. And, the centers remains the same. The examination fees will follow the guide that you know already. When you open your portal, you're going to see that. But if you're in level 2, one paper is 911, two papers 1670. If you're writing 3 papers, around 2,305. If you're writing 4 papers in level 2, you are going to pay 2,788 Ghana cedis. 5 papers, it goes up to 4,181. If you're in level 3, one paper in level 3 is 1,104. 2 papers in level 3 is 1,904. If you're writing 3 papers in level 3, it's 2,636 Ghana cedis. If you're writing all 4 papers in level 3, that is 2,926 Ghana cedis. So these are the registration fees also that you have to be mindful of for the November 2026 examination. Finally, late registration will be allowed. Okay, so late registration will only be accepted within a week after the deadline of registration, and late registration attracts a penalty of 400 Ghana cedis. But boy, why will you do late registration? You have from 1st September to 16th of October to decide how many papers you want to write, which papers you want to write, and whether you're going to be writing the exam at all. But you got to understand that, the fees are, becoming a bit incremental. So it means that in addition to the emotions, the pressure, what you are going through to, study, write the examination, financially, you are also going to be committing a lot, looking at how much you have to pay just for the examination, before tuition even comes in, before books comes in, and you can be running into thousands of CDs just to be able to write the exam. That means that you cannot go to the exam or fail the exam. That means that you need to be prepared and only sit for the exam that you think you can write. If it is one paper, prepare well, go in there and write the exam. Because level 3, one paper now is a little over 1,000 CDs, okay, 1,104. One paper in level 2, 911 Ghana cedis. That's on the high side. It's on the high side. So please work hard. Please study and make sure you put yourself in the position to go into the exam or write the exam with confidence, and most importantly, pass the examination. Remember that you can download the Nhyira Premium mobile application on the Google Play Store or the Apple App Store. We have a lot of free videos available in the mobile application exclusively that you can get access to, and some blog posts also available that you can get access to. So if you don't have the Nhyira Premium mobile application, I will entreat you to download the Nhyira Premium mobile application on the Google Play Store or the Apple App Store to get access to our free premium contents that are exclusive in the mobile application, as well as our blog videos, and then get access to our premium content as well if you enroll in any of our courses. The mobile application is very intuitive, very user-friendly, and you are going to be able to get access to these contents across various issues in the mobile application under the free video sessions. We cut across various issues: personal development, personal finance, business issues, ICA issues, ACCA issues. Then the blog posts are also there covering the same topical issues across board to help you so you can put yourself in the position, in the mindset needed to go after your goals and, most importantly, become successful. So thanks for joining us on the stream, and I'll catch you on the next one as we continue with our discussion.